waiting. All right, good afternoon, everyone. We're going to call the meeting to order. I will announce my co-counselors. Counselor Hogan, Counselor Nave, Counselor Caldwell, Counselor Peniagua, Counselor Williams, Counselor Monto, and myself, Jones-Rouser. I'm sorry, Kimon, you want to announce your title?
Sure. Kimon Jordan, Director of Housing and Neighborhood Planning.
All right, thank you. And we are meeting to discuss the establishment of the new procedures for the seizure of tax sales, delinquent tax properties through the land bank, based on Article 11, the New York State tax law. And if you want to open up to discuss?
I can.
Okay.
Do you want me to give you an overview of what the legislation is looking to do? So historically, the municipality has followed its tax act in order to acquire title to tax delinquent properties. The seizure process has been going on for decades, and it has worked up until this point. Recently, not a New York State case, but another case in the country challenged the way in which municipalities were seizing delinquent tax properties. The issue became whether or not municipalities were obligated to provide an opportunity for any excess equity to be distributed to the owner or other lien holders. And the Supreme Court of the United States ruled that, in fact, that process needed to be complied with in order to avoid a violation of the Constitution. So with that, my office undertook a review of our current policy, working with the Land Bank and the Land Bank's Council and other organizations throughout the state and quite honestly the country to try to come up with a process by which we could comply with the court's new dictate. And what is before you is that plan. The reality is it does not change in any way what we had been doing. All of the outreach that MBD has done historically has continued to occur. It will continue to occur. All of the notices that previously went out, and there are multiple notices that go out to the affected parties, giving them an opportunity to come current, to redeem, all of those notices continue to go out. What now will also happen is an additional notice will go out prior to the city seizing the property, notifying the impacted parties of their right to file a claim for any potential surplus monies. It doesn't mean there will be surplus monies. It doesn't mean they will get any cash as a result of the taking. But if they want to participate, they have to file a claim. In the event that we receive a claim, the process we undertake will change a little bit. The land bank will still be involved. The land bank will still be the recipient of properties that they approve by their board to take. We will transfer title of those properties to the land bank as we always have. But the land bank then will step in and act as our agent for purposes of undertaking and conducting what we have called the surplus proceedings hearing. It will be required that they obtain a third-party appraisal, an independent appraisal, to give us the value of the property. In the event that that value comes back in excess of what the city and county are owed in totality, in that event, there will be a proceeding. If the appraisal comes back and there are no excess proceeds when you compare to what is owed to the city and county, then no excess proceeds proceeding will be required and the transfer to the land bank will continue as it always had. In the event there is a claim and the appraisal comes back evidencing that there may be excess proceeds, the land bank will undertake to have a judicial hearing officer conduct that review all the claims, and determine the amounts owed. At that point, the land bank will be responsible for paying those amounts. There's a mechanism in what's proposed to you. They will post a bond for our benefit to secure those amounts. We will draw upon those amounts to make those payments. The land bank will, at the end of the day, come back to the city and seek reimbursement for the amounts paid on its behalf. And that will happen on an annual basis. through the standard appropriation procedures. There is a mechanism in what is proposed for them to seek that appropriation to happen mid-year in the event that, you know, they incur an enormous amount of costs that were not anticipated. We don't think that will happen. We don't believe, based historically on what we have taken, that many of the properties that are seized would fall into the category where there are surplus, the necessity for a surplus hearing, but we can't give you, you know, a definitive on that now. What we do know is that the process we have laid out, we believe, will satisfy the requirements of the Supreme Court. We believe other municipalities are looking to us to see how we handle it. The state is still working on their own process because we have our own tax act, and the state told us, you go figure it out for you. Anyone who doesn't have their own tax act is governed by state law, and they are working on a process for themselves. So I think this sets us up to be able to move forward to acquire those properties that are tax delinquent, get them to the land bank so that they can get turned around and become productive properties and back on the tax rolls. I can't see the audience. I do believe that there are representatives from the land bank in the audience, as well as counsel for the land bank, in the event anyone has any questions with respect to the flip side of this. And certainly I'm happy to answer questions if you have any.
I have a question, just so I'm understanding this. So the process, this is Rashida.
Hi, Rashida.
Hi, Rashida. The process of the land bank taking whatever, it was a lot just said, so I'm trying to absorb, hear it all. The process of the land bank having to come back to the city for whatever they paid, right? How is that when it's supposed to come to us, then to them? Like, has to come to the council for approval first, right?
So it is a retrospective kind of process because the land bank won't know ahead of time how much money is required through the excess surplus proceedings. Neither would the city. So you have to take the property first. You have to see if anyone files a claim. Then you have to get the appraisal and compare it to what is owed. So it's only after the city takes the property that you get to that surplus process. So there's no way for the land bank or anyone to know what that's going to look like. So the land bank has agreed, assuming approval by this board, the land bank has agreed to shoulder those costs for the first year, to post a bond as necessary to protect the city so that we know we can pay those amounts. The mechanism by which they can control how far into this they get is their board has to approve acceptance of every property before we seize it. We give them a list. MBD creates lists. You see them. Those same lists are provided to the land bank. The land bank decides, yes, we want to take these 50 properties, or, oh, we only want to take 40. Once the land bank approves them, that's what triggers the city to go and really commence the seizure process, because we know that the land bank is willing to accept them. So the land bank has some control in terms of how many properties they take. This first year is going to be a test for all of us. We don't know what it's going to look like in terms of surplus monies. We assume, based upon some historical data and what we see, and that there won't be an enormous amount of properties that fall into the surplus bucket, but we don't know that. So what the land bank has agreed to do is shoulder that burden for the first year, post the bonds as necessary to protect the city, to make sure that the monies are there. And then at the end of the year, they will come back and ask the city to reimburse them for those surplus monies. The payment of those surplus monies is a responsibility of the taxing jurisdiction that seizes the property. So it is your responsibility. They are agreeing to act as your agent for purposes of conducting those hearings and paying those monies. I don't know if that answers your question, Rashida.
It does, but I'm still a little confused how they're going to come back and bill us when we don't know. Is there like a cap?
I'm sorry, I can't hear Rashida. I see her talking, but no sound.
Can you hear me? Oh, I'm sorry. Can you hear me now? No? Can you hear me now? I don't know what happened. I don't know what happened.
Can someone else try talking to see if it's just Rashida?
Say
I
Hello,
even
hello,
see her
hello.
green
Can you
light
hear
on.
me? Can you hear me?
Oh,
Did you hear that?
Because I
Hello?
think it's on a small delay, so you just have to keep talking.
I'm just trying to understand the process of this. I mean, it is not the mic.
Keep talking, just keep
Okay.
talking.
I'm just still trying to understand the process.
No.
No? Okay. Kayla, you
Oh, it's saying something on the,
Patrick,
long.
your
Yeah, for
quality.
legal ways. Not
I
really
can hear you,
Kayla.
but give your phone to Rashida.
No, sir,
Okay.
it said something. It said like your quality
Yeah,
something.
it's not really the
It went
land
away.
Collaborate in this chat. Do you want me to, I could email you, I mean, I can write to you.
I'm just
So
trying
we
to
can
see.
hear you fine.
Oh, I can hear you, Patrick.
Okay.
You can hear me? Want me to come closer?
Is it just
Oh, now I
basically?
can hear you, Rashida.
Oh, okay. All right.
All
So
right.
I'm just trying to understand the legal aspect of it to make sure that like we're approving stuff before we know. Like that's typically not how we do it here, right? And then it has to come back to council and say, yeah. What if we say no? What if we disagree with whatever the land? Legally, I'm trying to see how this makes sense. That's all, because it seems like we're doing it opposite than what we normally do to get approval, and then we got to come back and say, well, Land Bank said this, and we might say absolutely not, right? It doesn't make sense. So I just want to make sure that I'm understanding this process, because I just don't understand that.
Okay, so, and it's a really good question, and the answer probably won't satisfy you 100%, but no property is ever seized without the approval of the Common Council. So the properties come before you, you approve them. The Land Bank has previously approved accepting them, but they don't get seized until this body approves the taking of those properties. The most we're going to be able to do at any given time is give you a list of the properties, which you have always gotten when you approve them. We will add a couple of columns to that. We will add a column telling you the total amount owed to the city and county. So that would be taxes. It would be past due water bills. It would be judgments that properties have against them because they didn't comply with a code violation. So everything, not just taxes, everything that is owed to the city or county, we can give you that dollar amount. We can give you the assessed value, what the assessor has the property valued at. That is only a ballpark. It is not what is going to be appraised at, but it gives you a benchmark in general. That's the best we're going to be able to do, because the only way you can determine the value is either by selling it at an auction or getting the appraisal. And so getting the appraisal is what we believe is the method by which we need to do this in order to be able to maintain our structure as that we want, which is the cooperation and the partnership with the land bank to get these properties back on the tax rolls to people who demonstrate an ability to maintain them.
So Sue, it's Jimmy. Can you hear me?
I can, Jimmy, go ahead.
So, okay, so we seize the property and the fair market value appraisal, would that be on day one or as fast as the land bank can possibly get that appraisal?
Yes, there are timelines in the legislation. I think it's either 60 or 90 days from the date of the taking, they have to get the appraisal. And we have to build in a cushion because there's very few, getting the service done right now can be challenging. There's not that many appraisers out there. So they have a certain amount of time, but within 120 days, the whole process, once we seize it, will be done.
So this might be a question for Caitlin, but so we are going to get an appraisal on the property regardless if there is claim laid to it, just so we have that appraisal or no?
Only
No,
people that claim it.
only if someone
Claims
files a
come back
claim.
in.
That's the only thing that will trigger the requirement to incur the cost to get the appraisal.
Okay.
Otherwise, this system, will continue to operate just as it had.
Okay.
We will get your approval, we'll seize the properties, we'll transfer them to the land bank.
And legally, there's only, I'm sorry, go ahead.
Well, I was just gonna follow up with the appraisal process. So the appraisal process is based on regular real estate appraisals. Like, it's not, we don't have an appraiser on staff, basically, so it'll be
Correct.
random just as real estate happens. Okay.
And the cost of the process goes into what is owed to the city. So the cost of the appraisal will be factored into the amount owed to the city, the cost of a hearing officer to do the process, all of that goes into what is owed to the city when we determine if there is any surplus monies.
I'm not trying to open up a can of worms, but through the process of someone asking for, what did you say?
The process to transfer to the land bank,
Appraisal. Yeah, so how long does the constituent or person have time to, can they come back 2 years later and ask for that? Or is
No.
there a time, it's,
After,
the amount of, if you're asking me how much time does a property owner have to come and save their property, that all happens before we take the property. They are given multiple notices to come in and pay their taxes, to redeem, etc. If
I
they
understand
don't,
that. I'm
they
sorry.
have,
I'm talking about after we take it. There's nothing that's gonna cause us any situation where it comes back and says, wait a minute. Is there a timeline legally? Is there a timeline that they can come back and say, wait a minute? A year, 6 months, 90 days?
do they want the money? If they
So-
want surplus
They-
money?
Or-
Yeah, there's,
So I think it's the second opportunity that she's asking you the question about.
Yes.
So it sees, it goes through this process, they get an opportunity to appeal to the land bank.
Yes.
How much time do they have to do that? To file a claim, to come back?
yes,
Yeah.
okay. Yeah, so they file after the, all the other seizures come in. I think it's like they have 60 days after the, after all of the claims have come in. So once the claims have come in, then the city, or Caitlin, you might be able to speak to it a little bit better.
I think we should just have clarity to that. I mean, all that's gonna be important
Yeah,
before we
it's in
move
there.
forward, just to make sure that personally, I understand. I need to make sure I understand.
Sue, this is Caitlin. The question is, when will the property owner have an opportunity to file that claim? So they're getting all their regular foreclosure notices, and they're getting the notice that they can file a claim, but they would have to file a claim before the foreclosure, correct?
So Sue just sent
sorry, say it
a
again.
message. Hi, Assistant Corporation Counsel Patrick Parkinson. Hi, Sue.
Patrick.
Oh, we can hear you now. I don't know if you're having trouble.
No, it's very hard for me to hear anyone speaking, and sometimes the counselors come in and out. But if the question is, how long do they have to file a claim to excess proceeds? The notice to file a claim goes out to property owners and interested parties at least 30 days before we take the property. They then have 30 days to file a claim.
30 days
That's on
before.
top of all of the outreach and all of the other opportunities they've had to come in and cure the default. They
That's not
then
just-
get this extra notice to say, here's a process. If you want to participate, here's how you do it. Here's the form. Here's how you file it.
And that's also to other lien holders as well. So it's not just the homeowner, it's all lien holders.
That was my question, Sue, again. So mechanics liens from contractors, anything that's sitting out there, they can all lay claim to the surplus as well?
I'm sorry, Jimmy.
Yes.
Okay. I got my question answered.
Can you just stand up, please?
I'm John Sitt. I'm the
Thanks,
attorney for the
John.
land bank from Hancock Esterbrook. That is correct. As long as their interests are of record at the county clerk's office at the time the seizure takes place.
So theoretically speaking, the city could be in the spot where we're paying for old renovations or old contractors that have mechanics liens on the property that we just seized, right?
Only if there's a surplus.
Okay, if there's a surplus.
If there's a surplus, then
And
that
only
money
if
would
there's a
be.
claim, right, Chad?
Yeah,
Correct. If there's no claim, you won't even know if there's a surplus because there'll be no appraisal. If a claim is filed, there will be an appraisal done. If that appraisal determines there's a surplus, the property is worth more than was owed, then that surplus is called the delta, the difference. The land bank's going to push that money out the door, and it'll be distributed in order of preference. If there's a first mortgage, they come first. If there's a mechanics lien, they may come second. And if there's any money left over, it would go to the owner ultimately.
So this might be for you. So have we ballparked what the possible cost to the city is in coming? I mean, can you even come up with that number?
That's a better question for Caitlin.
I had to guess, I would say maybe 300,000 a year, but we really don't know, like Sue said, and we are kind of looking at this first year as a test case. We're constantly in close communication with city staff. If things escalate more quickly than we anticipate, we'll pause and reevaluate.
So if there is leftover surplus that would ultimately go to the property owner, what is the surplus that the city is paying to the land bank back?
Well, so we're advancing that money, putting it in an escrow account. We're making them whole. They have to be paid within 120 days, like Sue said. And then at the end of the year, we're going to come back and say to the city, we paid out X amount, and we're seeking reimbursement.
Caitlin, can I ask? I've got a big question mark on my paper here, and that makes me uncomfortable from a financial statement having a big question mark. We heard from Sue this year will be a test. We don't know. There's no way to know what that'll look like. We don't believe that many of the properties will have a surplus. And then you just floated the number of 300,000. Has there been an attempt to look at the past 12 months, 24 months, and try to?
That's what I'm basing that estimate on.
Okay.
And there is a fail-safe in the agency agreement that says if we hit 500,000, we will come to you mid-year. So we're going to need to do that because of our own cash flow issues. So if it hits that point and we aren't reimbursed and you guys aren't comfortable going any further, we're all going to pause.
I have
And
a
you
question
can amend that number if you want. If you're not comfortable with 500 and you want it to be lower.
Understanding that, Sharon Owens, Deputy Mayor, understanding that pausing means we're not doing this anymore because
Well, in
of the
effect,
Supreme Court
We've been in a
order.
pause for months now.
Because of the Supreme Court order.
Yeah. So, I mean, we've been in a pause for months now. So that means no delinquent, tax delinquent properties, no abandoned houses, nothing that affects the stability of our neighborhood has moved forward at all because of this ruling. So, I mean, we don't have any way to address these problems without, and I want to commend both the law department, the administration, and the land bank to come up with this unique way to, like, address this issue, because otherwise we're in a pause, a stall.
And
This question is for the, go ahead. It's,
Can I just?
Go on.
I'm so sorry. I just want to comment on Counselor Hogan's thoughts as well. If, regardless of what method you would choose to do this, the city is responsible for paying the surplus, the equity. So this process gives you a way to do that if and only if there is a claim filed. And if and only if, which would always be the case, there is actually equity involved. But there is no mechanism under state law or your local law or now the ruling of the Supreme Court of the United States that is going to allow you to take tax delinquent properties without paying equity when it's owed.
And that's what I want to touch on, Sue.
I recognize how uncomfortable that is, not knowing what that amount is ahead of time, but that is the reality of the choice you're facing. Either make the decision that you are never going to foreclose on tax delinquent properties, or we need to find a path forward. So it's a hard pill to swallow, but I think that this proposal gets you there in actually the most fiscally responsible way we can at this moment in time.
So when you talk about equity, can you hear me? Hello? Hello? Can you hear me? Can you hear me now? Sue? No. Okay. Can I try that mic over there, please?
If you have her on the phone.
I can either try calling her, or I can type your question if you want.
Okay, because I know that I just heard when they talked about the land bank bonding, and then they would come back for reimbursement. So for me, this is what I'm curious about. They come back to the city for reimbursement. How is the city going to pay out that money? Are we going to bond for that as well, to pay back the money?
So your question, just to make sure I understand, your question is how would we ensure that we have the funding to reimburse?
How are we going to be able to fund it?
One way that you could do it is for the next fiscal year, you could allot a certain amount of money that you think would cover this. If it's 300, if it's 400, But
You
for
don't know, so how
now,
are we
getting
gonna
us
know?
going, the land bank has agreed to shoulder that. So we're gonna have some test cases that maybe we'll be able to rely on that can give you more comfort in your next fiscal year to budget monies to pay for any surplus proceedings.
So with that also, and this is more to the city, has the city even thought about any individuals that might come back retroactively about properties that have been seized prior to this? And are we budgeting for a possibility?
So that is the question that was posed during the study session, that the Corporation Council said that you all need to go into executive session.
Oh, yes, that's right. Okay, all right.
So let me ask this question, Caitlin. So you do the first year of it, you see what the total amount will be, and then that would give us an indication of what we have to do for next year. But my concern is this: what if the amount comes in bigger than we actually thought it was going to be? Then what do we do?
Okay, Tim Rudd, Budget Director. All good questions. I think, because you, Councilor Williams, described the big question mark on your sheet that gives you agita that causes a lot of this. So one, I think we're gonna have to set some money aside to fund this process. It'll be a round number, probably $300,000, $500,000. We have to do it so that we can seize properties, so that we keep the incentives going for people to pay their property taxes. There's uncertainty to it. There's a lot of uncertainty around many of the numbers in the budget, so I probably understand that more than many people, which is why there's always this falls up and this comes down, and when I tell somebody one story, they're kind of like, oh my God, well, how are we gonna fix that? And usually things kind of bounce. So when I hear about the data that's gonna come to the council, Sue was describing, you're gonna see essentially all the city liens, and you're also gonna see the assessed value. And I suspect, knowing the typical condition of a land bank seizure candidate, that they're probably on the high end, like the assessed value is probably high because it's not taking into account that it's dilapidated house, right? So I think if you just keep an eye on that, you know the house is assessed at $40,000. You know there's $25,000 owed. There's a potential of $15,000 to be paid out in a taking, and then we track that, and you can take 100 properties or however many, depending on how that math works, and be pretty confident you're not going to blow the budget for the year. That allows all of us to move forward seizing the properties. And then in the event it ends up being a little higher than we thought, we just slow down at the end of a fiscal year and fund it appropriately based on the data for the next year. But I don't see it as a big budget problem. It does require some money so we can do the right thing. But
You don't, because we don't know how many people are actually going to file a claim, so you
Well,
can't
and that
see the
too.
big budget problem right now.
I think I would also take the low end of that number. Maybe a lot of people will not.
Well,
So I'm gonna say this. First of all, you guys are the expert for the legal part, so I'm not. I really have a lot of faith in it, but honestly, I have a lot of questions. I'm really concerned about this process and what way this is gonna work and how effective. And I know it's a trial and error, but trial and error can also put us in a situation. And I want to be more clear of how this is really gonna pan out, right, with the people. Now, my other question is, if you're saying you're gonna take 50 houses, estimate, right? And you said, Director Rudd, that part of the incentive is to take houses, right? Get people so they pay their taxes. I disagree. I believe that people want to. I want to encourage our community to pay our taxes because that's how we get our revenue and our community to keep going. But we also have a bunch of houses that are already in land bank. I would urge that we just make sure we go through this with a thin comb and just make sure we get all our quirks so that we don't have to backtrack, and make sure whatever houses we have now that we are doing, pushing those through to get revenue going, but also just to make sure some of this stuff is clarity, because I'm not really clear about how this is gonna work, as far as legislation, because it seems like we're going backwards, then forward, and this thing from the Supreme Court just passed. So I would definitely like to make sure that we are hitting everything so that it doesn't come back on us later.
So nothing can come forward to you, and nothing has until we solidify this legislation and can get this passed. So nothing else is going to be coming to the council. So everything that we've had in the pipeline, as Sue talked about, all of the due diligence that Kimona and her team does, they've still been doing. So we give people opportunity to resolve the tax issue right up, just like we always have been. Now there's this next step that, quite frankly, to the Councilor Hogan's point, Sue and the Land Bank have been working forward towards a possible solution that we think is the best solution that nobody else in the state has figured out yet. So we're really out ahead of everybody else in how we're going to move forward on this. And so the issue about back is what you're going to talk about in executive session. But again, and no one wants to go into this not knowing how much we have to budget, but we really are not going to know until we get moving in the process.
How many do we have seizable right now?
That's a great question.
Yep. So last year, we sent out 60-day notices to over 900 properties, about 200 redeemed through our noticing and through our outreach efforts. We are working to pull the numbers again because some have fallen off and some have been added, but I estimate around 900 or 1,000.
So come on, just let you speculate. If we don't have the process where we seize property and send it over to the land bank, what would you think? How many of those people would be inspired to pay their taxes, you think?
So, you know, I don't think.
That's an unfair question. I'm sorry. I say zero. They wouldn't, why would they? If we're not going to seize their property or the threat of seizure, what the heck, why would they pay their taxes?
Yeah, and I think, you know, a handful of people think that way. I mean, our goal is to get this process underway so we can begin moving them. I think as Deputy Mayor mentioned earlier, we've continued to do foreclosure prevention outreach for the past 8 months, even though the foreclosure process has stopped. So we've held foreclosure prevention workshops with home headquarters and the Financial Empowerment Center. We've sent out additional noticing. We have one staff, Kaylin Hubbard, who's a Southside planner. Her role is to do foreclosure prevention outreach. We've done phone calls to all numbers that we have in our records, so information from our code enforcement records, water department records, and then this spring we'll be moving to do door-to-door engagement for whoever we haven't been able to make contact with. So we've done due diligence with the outreach process, but we just need this key piece to begin moving them through again.
And if I want to submit, I've, obviously been on the council a long time, and I've seen a lot of budgets, and I don't think there's ever been, we've been able to predict exactly what our budget's going to land on. I mean, there's always unintended costs. There's city departments that run overtime, and all of a sudden they're over budget. There's all sorts of things. And in fact, we just went through a completely bizarre year when we had COVID. We had no idea what our revenue was going to be. We had no idea what we'd have to cost. We had no idea what we were going to have to pay people. So I think this city can handle a $300,000 unknown cost, speculative cost, as far as this goes.
If I can just jump in to try to take a stab at Councilor Hogan's question, Michelle Spansky, Deputy Commissioner of Neighborhood Development. So to Kamon's point, we had about 925 properties that were in this phase as a ballpark. That 200 that redeemed roughly around 25% through all of this outreach. I think we had thought going into this phase that we were going to see, for comparison's sake, phase 17, the one that we last wrapped up, we ended that total phase of also similar number of properties, ended that phase with overall about a 50% redemption rate. Because of in addition to kind of the tax trust policies that we have in place for owner occupants, we had actually expanded that to rental property owners who meet particular qualifications. And so because of that additional expansion, I think that we thought that through this process, we were going to see redemptions at a much higher rate. But what we've actually seen kind of play out in the data is that even despite all the door-to-door that's been going on for the last 8 months, while everything has been further paused again because of the Supreme Court decision, we're not seeing those numbers come through. So I think that there's always kind of a back end action that we see people take once they get kind of the official 30-day notice. That often kind of will spur people to fully go get into the tax trust. But to Councilor Hogan's point, we have seen it play out in the data that if there is not additional escalated action being taken, people are not going to pay or redeem, even though we have the tools and the programs available to them.
I have a question. Now, so we'll go to the Department of Law. Do you get legal documents from a person who's willing to release their property or from their attorneys? I mean, when you say, well, we're seizing your property and that's it, do you go to the person or to their attorneys and saying, we're gonna take this property for non-payment for how many years? So we have a legal document that he's agreeing to this release of this property, so they don't come back and say, oh, well, they didn't contact me. You know, so where does the city of Syracuse protect itself? Okay, then we also got to deal with LLCs, and you want to seize property, maybe from LLCs that maybe, oh, they're out in California, and then you got the person, let's say, who's renting the apartment, they're stuck out in the snow.
Counselor, if I'm understanding the question correctly, I think what you're talking about is something that's all fully established within the existing tax provisions. So the way that that's handled is through the, we do a title search to identify who the lawful owner is and interested parties. Our legal department goes through that whole noticing procedure. That final 30-day notice is sent after that title search is complete to ensure that the true and rightful owner is identified. And that, in effect, that final 30-day notice is that outreach to that entity, whether it's an LLC or an individual owner. That is what is sent out. I would defer if there's any other questions about other new stuff being added, but the whole process of Caesar itself, that title search will still be the core component.
See, I'm really concerned because you got an LLC and you got back taxes. They don't care, okay? I can give you an example. On the north side, we had a situation some years ago, LLC, right? Shut the power off. Young girl wanted some light, lit a candle, caused a house fire, and she lost her life. You know, this is an issue that we're talking about humans, beings, though, and in my district, we have a lot of many new Americans, and they are dependent on these, they pay a landlord for rent, and they don't take up the property, or they just pocket the money, they don't pay their taxes. They could say, yeah, take it, I don't care. But you know, what about the people that live in those apartments? Where do they go? I'm concerned about them.
Well, I appreciate the concern about tenant occupancies and the safety of those tenants. That is an issue that is separate and apart from tax seizures. And it can be addressed in different ways, but in terms of seizing properties, we are required by state law to take certain steps and to notify certain people. And our tax act mirrors those requirements, and that's what we're obligated to do. So having a different discussion about what we will do with displaced tenants, I think that is the conversation we can have with NBD separately, and I'm sure that they already work with those groups to help them relocate. With respect to Councilor Caldwell's prior question, I just want to say I don't look at this as going backwards. Nothing in the original process has changed. What this is doing is actually giving the owners of those properties an additional opportunity to participate. It is yet another notice to them. Nothing in the process, with respect to the owners has changed one iota. They get an additional notice with an additional opportunity to participate in a way that they previously had not been able to do. So the biggest change for, I think, this body is what Councilor Hogan was talking about, which is getting comfortable with a little bit of unknown in your budget. Because we can't tell you what those amounts are.
And I apologize if you misunderstood me. It wasn't about the constituents. I think it was nice that we added another step to support, making sure it was about the financial part on our part. It wasn't about the extra step. It was the extra step with the finances that we're not knowing what the surplus is when we're in a city that we're already in a deficit.
So, Caitlin, to what Pat said, I think any of us that remember how we used to seize properties before the land bank, none of us want to go back there. At least for me, I'm not a proponent.
Actually, Councilor Mono, we never seized properties. The city never did. And the neighborhoods were beset with empty, abandoned houses, delinquent houses. And before the land bank was created, it was brutal.
Exactly.
And then, to Councilor Nave's point, I think we think about these empty houses destabilizing neighborhoods. 4 out of the 5 houses that caught fire in my council district were all empty, abandoned houses, and within the last 3 or 4 months, endangering not only neighborhoods but our firefighters.
So to all of that, let me ask you, what does this process do to your bottom line? And that you have to speculate, I know, but I'm concerned that this affects you in a negative way that we need to think about.
Well, that's why we're seeking reimbursement from the city. We just simply can't afford to absorb this, what would essentially amount to an increased purchase price for us. We've broken even the past couple of years, largely due to significant financial support from the city to help us cover our property maintenance costs. And we,
Because the 750 that we put in the budget, or the mayor put in the budget now, that is going just to maintaining the vacant properties that you have already taken.
that's correct. The $750,000 that the city has given us the past 2 years in a row have gone towards property maintenance expenses, mowing, trash pickup, snow shoveling, boarding, that sort of thing.
And what's that price tag look like? What was your cost last year just to maintain the vacancies?
Oh, I would have to go back
More
and
than the
tally it up, but
more
we
than the
spent
$750,000
$500,000 just on trash removal. So
Can I ask one more question and then I'll be done? So I want to talk about the foreclosure process, right? I know that at some point foreclosure was taken forever, which gave them an opportunity to redeem because it was a long process. If I can remember, I think that we kind of sped up the foreclosure process to where it's not taking as long as it had.
I can speak to that a little bit. So we built in some changes to the foreclosure process. So if you recall, last May, we reached out to counselors on some of the changes. So instead of putting, if you remember before, we were putting maybe 25 or 30 properties before council at once. We are proposing to place more properties before you all, so 100, 150 as one line item on an agenda. And what we'll do is at the beginning of the foreclosure phase, so phase 18, we would send counselors that entire list of properties that we're looking to foreclose on. And that list would include contact information for the owners, property information, as well as all of the outreach that Neighborhood and Business Development has done to date for those properties. In addition, so we would send all that information out to you all, and then 2 weeks before the study session happens, we would send you the list again with the list of properties that are going before you on the next agenda, and that information will be updated. So counselors will have weeks before the properties get on an agenda to do any additional outreach or engagement that you would like to do within your districts. And then once that is done, we just ask if you do make contact with any owners, you let Neighborhood and Business Development know. We'll add that information to our system, and then we can pull properties off of agendas.
And I want to mention, through the good work of Ms. Jordan here, is that also what is really illuminating on that sheet that she always gives us is the amount of code violations in some of these vacant properties and how dangerous these properties are. And I appreciate you including that too, because that's exactly shows up what kind of situation we're dealing with some of these
Okay, are
properties.
you finna answer my question?
Yeah, so a couple other things that we've added in here too. So we, right before the Supreme Court decision was made, we had identified a new title search company. I think that was one of the challenges that we had was the pace of time that it was taking on the back end, understanding that there's the noticing that we go through, there is going to be a minimum amount of time that it is always going to take, even if everything goes as smoothly as possible. And so that's roughly about 6 to 8 months just to get through all of the different amount of noticing. So in order to balance kind of full due diligence of us sending out an initial 60-day notice, the time that it takes that for any of us to do our door-to-door, an absolute sprint, that's a best case scenario.
And that's 6 to 8 months. During that period, can that property owner reclaim their property?
They can redeem their property at any point up until even
That's where
after
I
the
was going.
council authorizes the transfer of it. As those additional kind of 30-day notices go through, up until the point of that final 30-day notice expiring, you are still able to fully cure the foreclosure. So.
I have a quick question, and I think you answered this before, Caitlin. As Councilor Navi said, not really the abandoned ones, but the homes that people are in and you're foreclosing, there's a process that you guys are working on. People have an opportunity, land bank is taking it and allowing like maybe them to purchase or to rent it. Is there, could you briefly speak about that?
Yes, we do have a policy called our tenant to homeowner program. So if a tenant is living in the home at the time of foreclosure, they have the first opportunity to purchase. Unfortunately, not a lot of them do. Either the home is in really substandard condition or they simply don't have the income sufficient to buy the home. But they do get the first opportunity to purchase non-competitively. If they need relocation because the home is unsafe, we partner with Catholic Charities, and we have a contract with them every year to provide not only case management service, but also a pool of money for cash assistance for moving, first month's rent, security deposits, and things like that that people might need to help get them into a better place.
And Caitlin, do you anticipate having to incur additional administrative costs due to the new process? I guess either you at the land bank or the city?
Well, I believe we're going to be able to recoup those administrative costs from the surplus.
All of them? Okay.
There could be an instance where we do the appraisal and find out that there is no excess proceeds and we eat the appraisal cost, but that's $500 at most.
And if there's no surplus,
Then we just,
absorb it.
yeah, exactly.
Okay.
Just to kind of highlight the potential uncertainty of it, because I feel like there have been multiple iterations of Caitlin and I talking about how does the city support the land bank, and there is the line item that we give that's been $750,000, and there's certainly been times where I say, but we also give you the value of all that property that we've given you. And I'm not saying that's the value of the taking, but we are taking $40,000 tax balances for giving them, transferring them for $1. So let's just presume it wasn't greater than 40,000, but it was 20,000. That there was 20,000 of value that went to the land bank. If there were 100 houses in a tranche and the average was 20,000, there was no taking, but we gave them $2 million of subsidy.
And I think we
So there is potential value, but I think there's times where Caitlin says, that's not true. They're actually worth negative because I need to tear it down. So then she's saying you're actually transferring me a liability, that's why you have to give me a thing. So a lot of it is uncertain and it depends what perspective you're holding, but that just kind of shows 100 houses how you could say it's negative, you could say it's zero, you could say it's 2 million, and they're all relatively relevant.
And I think we got to be cognizant of the 1,200 houses that the land bank has put on back on the tax rolls too, because otherwise those properties would have just been demolished or still out there if it wasn't for the land bank. And the tax revenue that we've gained from that.
You have about 165 structures now. The rest of what you have is vacant, just empty land, right?
That she subdivides and really lays out a path for us to do other redevelopment. They're amazing in that partnership. Just to reiterate, the process we have right now in and of itself, we can no longer go forward on, based on the Supreme Court decision. And based on communication with Sue, the only option we would have is auction.
And that's terrible.
Thank you, President Hudson.
We remember,
Because they
President.
sold mine and I had paid my taxes.
Because in the auction process, the value is set at the auction. And so that is the unknown that makes many of you uncomfortable, as well as us. But the way we do it now is not an option anymore.
And please don't sell the liens to nobody in Illinois again.
Yeah.
But
I just wanted to,
just one quick clarification from my head, right? We talked about the taxes, that goes on, right? If they want to redeem. Water bill, that's added on. Then we're talking
been
about.
doing board ups.
And we're talking about the fees, any interest, any board up, anything that is attached to that property gets added on. So that's kind of going to negate if there's even any surplus.
Yeah.
They're not going to.
You might find yourself on the other side of the surplus.
Well, you don't have to pay it back. They done then. But okay, I just want to wrap my head into every dime that's going toward that homeowner. Yeah. Okay.
so just on the process timeline, and I know that President Hudson just asked a similar question, but from what I know, so you have the initial post-seizure processes, which are the outreach, and that's about 6 to 8 months. And then you have another, say, 6 to 8 months where once the procedure starts.
So if you draw kind of the line of at the point that the council authorizes prior to this new process coming into place, for the final noticing and title searches, it's typically 3 to 4 months. of additional turnaround time.
Additional, oh, that's what I was getting to. Okay.
So kind of the exact cadence of when this notice will go out, I don't know that that's going to change drastically of 3 to 4 months.
So in total, it used to seemingly be like, it's really a 2-year process before the property is actually seized. And then another almost year before it's kind of turned over to land bank. So that's an additional 3 to 4 months added onto that.
No, I don't think so. So I think kind of the overall process time, I think where some of that 2-year period of where things were sitting for a very, very long time, we were having that issue kind of come into play just with, again, kind of the turnaround time of title companies.
So now
The
that's,
council authorized several months ago for us to enter into an agreement with a new title company. It was a more expensive contract than what we had been getting before, but the thought was kind of like the status quo that we had been working with the prior companies, they were not able to do the volume, and so it was worth kind of taking that additional step. So our hope is that we can be, and we're very committed to making sure that we're staffing everything in such a way that we can keep things moving on that scheduled pace and as efficiently as it possibly can. Again, kind of balancing the need to make sure we're doing due diligence and outreach, but also not making it take longer than it absolutely has to, so.
But so does it look like that additional 3 to 4 months is now bringing it back to that time period prior to having that?
We don't expect that that's going to be the case. Maybe it could be, depending on exact cadence of noticing of how we send this out, maybe another month or so, but it's not going to be back up to that kind of a really extensive period. There still could be some extenuating circumstances on individual properties that require, if you do actually identify title issues in the process of doing that search, kind of in those sort of situations on a property by property basis, you could still run into issues where a property takes a while, but net overall for your average property that comes back with a clean title, that's the expectation.
So Sue, it's Jimmy again. Can you hear me? Is your office prepared to catch up on the backlog quickly?
That is our hope. We are putting resources towards it, reallocating. I know Councilor Hogan raised yesterday the possibility of using outside counsel or other resources to assist us. Certainly, if I feel we need to get the backlog done, we will, but I think that we're going to be positioned to move this forward. We actually have an internal meeting Monday, I believe, on our calendars to talk about exactly that. Assuming the council approves the changes and the amendments at the end of the month, what do we need to do to be prepared to pull that trigger? So, we are doing everything we can right now in preparation for that, and I am hopeful that we will be able to address the backlog.
I think Caitlin's ready for as many as we can throw at her, correct? Caitlin said they're running out of properties to sell.
And just
I
a
know.
reminder that
She
on
calls me all the time, Caitlin.
and just a reminder that on your agenda is the partnering legislation to actually enter into the agreement to be able to make this happen.
So in the event that you actually do have to go to outside counsel, financially, what does that look like?
Did you ask me what does that look like, Rita?
Yes.
So my office has the authority to hire outside counsel as we need it. So as you probably are well aware, we often use outside counsel to help us on litigation matters. We have used outside counsel to help us on complicated seeker issues when we have to do environmental reviews for actions that the city is looking to take. So in the event I felt that our staff could not, in conjunction with NBD, get through the backlog in a normal period of time, I could look to hire an attorney to help us do the process and get through the title reports and get through some of the other steps we have to take. But the issue for us really is a lot of it is internal. A lot of it is pulling information from our own systems. And no one from the outside world can do that. We have to be able to do that. We have to be able to prepare the notices. Certainly, we can have someone else send them for us. But a lot of the steps that have to be done don't lend themselves easily to sending them outside. So that's why I want to reallocate resources internally first to see if I can make it happen. And if not, rather than traditionally sending it out, maybe I bring on temporary help. Maybe I hire a temporary person or two to help us process the notices. But
But
we
do you
will
know,
be in,
financially, do you know what that would look like? I mean, how much will this cost overall?
hire outside, to hire someone outside.
To do this, what we're talking about?
Well, if we do it in-house, it doesn't cost anything additional. We just do it. We
know that,
we
but if
find
you
the
hire-
resources and do it. If I have to hire somebody, I would look to hire a paralegal to try to cut down on the overhead, because it's not something you really need an attorney to do.
Okay.
So, it's a hard question to answer. I can get you a better answer by figuring out how much time I think I would need per week, and then what I think I could get someone to do it for on an hourly basis, partnering with one of our outside firms, which is what I would like to do if I had to do it. So maybe $10,000 for a short period of time.
I personally can't think of a better way to spend our money to address this issue, because this means the stability of the neighborhoods.
Is the court system caught up soon? It's just the slowdown is just on our side?
I'm sorry, can you repeat that?
Okay, so there's nobody else slowing it down. It's just us, right? Okay. Never mind. I got it.
Okay, thanks.
Is that eligible to go to the surplus too? That the cost of additional lawyers?
I've got a question for Sue, but I think so. That would be part of your cost. I don't know if you can hear me, Sue, but hiring outside counsel, I would think would be part of your cost of conducting the foreclosure proceeding, and could be added to the lien amount.
We got a budget line for it.
Can you elaborate on outside counsel? Are we talking about city attorneys within the city with maybe the city law firms? Or are we going out of state?
But just to clarify, I'm the attorney for the land bank, not the city.
Oh, okay.
So that's a question for Sue. I don't know if she can hear me.
All right.
I
Thank
don't
you.
think that adding it to the MOU is
We
something-
outsource with other
Yeah.
city of Syracuse or local law firms all the time.
Thank you.
Yeah, so that wouldn't be a part of the MOU.
Okay.
That's just on the city.
I wanted to come back to Councilor Rouser's question about the process overall. It's not designed to add time to the foreclosure process overall. It's designed so that it can all be accomplished in the same period of time.
Yeah, that's what I was hoping.
Okay.
I just wanted to hear that.
Also, and once again, a law has been created that is going to impact the operations of how we do business. And our struggle right now is to figure out how to pay for it.
Right, that's the
That's
key
it.
issue for me, is how liable we're gonna be and the cost that it's gonna cost the city.
And we have no line of sight to
On
the
that,
dollar
right.
about that. But what we can
Right.
do, and what Kimon is excellent at doing, and Michelle, is documenting everything we have and getting through that documentation and that data, we can begin to kind of map out what this is costing us quarterly, through 6 months, through 3/4 of the year, so we'll be better prepared to anticipate.
And I just want to say this, I agree with you, because I've been around, and even before I was around, the way we did business when it came to vacant houses was terrible, and there was no real mechanism to move it. It was either auction, which was horrible, or it was sell our liens to somebody in a whole nother state, which was even worse, right? So I do hear you, because we do need to do something, but my thing is, taxpayers, which I know Sue said that we would talk about that Monday in executive session. So Sue, I'm hoping that in executive session, you come back with maybe what we're really looking at.
Or closer to.
Helen, I'm sorry, in executive session, come back and tell you.
Exactly,
Then you
I mean,
cut out.
exactly what we're really looking at, because I think that's something that we really need to know, so that we can make an informed decision when we're moving forward with this. Because it's gonna be a trickle effect. Because what the Supreme Court just did, they just tied us to all of this. So we really need those answers.
Yep, understood.
And Sue, I think I concur with Councilor Hogan. If $10,000 is standing in the way, if that's all that's standing in the way and catching up and getting all of these properties, these blights into Caitlin's hands, I would be all for that too.
Thank you. Yep.
If I may, I do just want to say, I know there's a lot of anxiety about this unknown number. But I want to remind everyone that I think the city is net positive since the land bank was established. We have helped you guys become a better collector of those delinquent receivables. Like Michelle was saying, when the threat of foreclosure seemed real, you had a 50% redemption rate. Now that we haven't been doing foreclosures since May, we're down to 25. So our willingness to take these properties really does encourage a lot of people to come in and pay. And I'm going to hand this out that shows what I think your net increase in collections has been. So it sounds like a scary, unknown additional expense, but I think that, you know, it's accounted for and compensated for by this partnership making you guys better delinquent tax collectors.
Depending on how dinged we get.
Well, that's a good question.
I think too, Caitlin, that it would probably be good to, I know that you do like yearly reports, but is it possible that you could kind of give a summary of some of the past properties where, once they were assessed through you guys' process, that, what the overall was at that point in time, to kind of give validity to like the quality of the houses, so that the understanding of exactly how many houses will possibly get people asking for, you know, reimbursement.
Right, right. So like I said, that $300,000 estimate is based on me looking at some of that past data over the past few years. Like Tim said, they're probably overassessed at the time we get them. We go in and we do a conditions evaluation, and we share all that conditions data with the assessment department. And every year when they come out with the new roll, we get tons of letters about them reducing the assessments on our properties based on that data we've provided to them. I have a hard time estimating based on the past, because we have our sales price and we know what we sold it for, but that's after we've cleaned it out, we've done some stabilization work. It's hard to know exactly what was it worth on the day of foreclosure. That's why we think it's so important to get that appraiser in there on day one, and that's my goal. So this is kind of a ballpark estimate, not knowing how many people might file claims and knowing that those values are higher than they would have been on the day of the foreclosure.
Can I ask one more question? Just something that I've observed from looking at different things throughout the city, right? On a lot of the property within the city proper, right, in the proper, everything is assessed for the same value. I think it's like $34,000. Why is everything assessed the same?
That would have to be a question for the assessment
It wasn't
commissioner.
for you. It wasn't for you.
Council, an unrelated note, Sue has to go to another meeting, so she'll be departing, and I'll read into, she sent a number of messages at the end, I'll read them to you all.
Okay. Yes, sir. Tell me.
Thank you,
Hi,
everyone.
President Hudson.
Thank you.
You just wing it, right? You just make up a number.
I'm not going to flip a coin. Matt OJ, Commissioner of Assessment. I'm sorry. Could you restate, please?
I think that most of the properties in the core of the city, I think I've looked at it, the different people's assessments or tax, yeah, you know what I'm saying.
Just
Yeah.
broad strokes, 28
Yeah.
to 34 is
Yeah,
kind of a tight
yeah.
range.
Why is that everybody's assessed at that?
I think, again, I don't want to overgeneralize, but I think by and large, in neighborhoods where there's been less market activity, they just haven't been reassessed for a long time. So the last time the ward assessor was there, that was by and large where the market data was coming in. I think as we've gotten over the hump with hotter neighborhoods in the last couple of years going into next year, I think we're going to be able to reassess and bring a lot more of those back down to
And I'm not
earth.
I don't want people's assessments
No,
to go
no,
up.
no.
But I want their value to be accurate, not $34,000 when they're really a
Same.
little bit
No,
more than that.
We share that, and especially with the drop in the equalization rate by 20% in the last 10 years, we're keenly aware of some inequities there.
I'm just curious, because that's been that way for quite a while.
We're on it. Thanks.
All right, would you like to share Sue's comments, and then we'll go to closing out if there's no other
And
further
I
questions.
apologize in advance, I didn't know she was doing this until we were into the meeting, but just for full disclosure, at 1:17 PM, Sue wrote, "We provide 30 days notice before we cease to file a claim. They have 30 days to file the claim." At 1:24, Sue wrote, "I can't hear now, no idea why." She then continued, "First, I want to thank you for allowing me to appear electronically, and I apologize for these technical difficulties. As this is a local law, it requires 2 meetings to approve, I will be back in the office on Monday and happy to answer any additional questions the council may have. We also have tax trusts that are available to eligible taxpayers who want to bring their delinquencies current. So just another opportunity to address homeowners who want to keep their homes. And at 1:49 p.m., Sue wrote, Helen is correct. Every dollar owed to the city or county for any reason arising from the property is added to the taxes for the total amount owed. That is the figure you compare to the appraised value to determine if there are any surpluses. And that's our final message.
That's our final message.
All right.
Okay.
And are there any other questions?
I would just
All right,
like to commend our two new city councilors for their first time out and sharing a meeting, how great a job they did.
Thank you, Council Hogan.
I love it, trying to do all the work.
All right, so, motion to adjourn the meeting?
So moved.
All right.
Second?
Well, second.
All in favor? Aye. Meeting adjourned.
Okay.
All right.